A 67-year-old man named Charles Roberts was physically slammed to the ground by Mansfield, Ohio police officers because he wouldn't put his hands against a vending machine for an officer to pat him down during an investigatory detention for jaywalking. Now, this will surprise you. The police chief has reviewed the officer in question's conduct and found it to be within policy. What's really fun about that is that this is going to be a slam dunk Monell violation once I explain how all of this works to the chief, and you'll get the benefit of the analysis too. Maybe another police chief on the chopping block for 2025? Let's talk about it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. So I had a bunch of people send me this video. This actually happened back in April, but the news has just now reported it because Mr. Roberts has secured an attorney and has filed a federal lawsuit. And that was a very good idea in this case. So what we're going to do is we're going to go through the news story and I'll explain step by step how the police royally screwed this up. Let's check out the video.
I can't breathe.
Charles.
What? My rib is killing me. I can't breathe.
I got an ambulance coming to check you out. Okay?
I didn't do anything.
Well, you were jaywalking. But
okay.
Last night, we showed you the wild body cam footage of a man getting body slammed by a Mansfield police officer after jaywalking. Good evening, everybody. I'm Brian Duffy.
And I'm Tiffany Tucker. The incident left that man with several fractured ribs, and now he's taking legal action against the department. 19 investigator Mike Mason has a story you will see only on 19 News.
What? My shoulder! Oh, God! Oh, God!
Charles Roberts will never forget the night of April 22nd.
Never experienced such pain.
It was just before 1 a.m. when he walked to the store just across the street from his house to get a soda from the vending machine. Mansfield police reportedly saw Roberts jaywalking, and Officer Michael Nelson took the call. 19 Investigates obtained Nelson's body cam footage showing what happened next.
Jaywalking? That's a No, I'm not.
Sir, I'm asking you to turn around and put your hands on top of the
Dude, wait! Don't call me dude.
Relax. Put them on there.
Watch my shoulder! Oh, God! Oh, God! Oh, my f***ing rib!
Simple directives, man. You gotta listen.
Roberts was checked out by paramedics, then taken to the ER room at Ohio Health.
For 6 days, I was in the hospital.
19 Investigates obtained a copy of Roberts' medical records showing how several of his ribs were fractured.
How many broken ribs? Or fractured?
7 broken and fractured, just smashed.
Records show 6 ribs were severely fractured, 3 so badly a surgeon considered stabilizing them with metal plates. At the hospital, Nelson cited Roberts for jaywalking, obstructing justice, and resisting arrest.
Resisting arrest, right? Huh.
On August 5th, Roberts appeared in court. Records show after pleading guilty to jaywalking, the prosecutor dismissed the other 2 charges. Roberts received a $25 fine.
It costs more money for what happened to me, being hospitalized, and now I'm in counseling and medications, than $25.
19 Investigates reached out to Chief Bammann, and on Thursday, he provided us with a written statement saying in part, "It's important to emphasize the use of force was not a response to the offense of jaywalking, rather a direct result of Mr. Roberts' actions during the encounter. To describe the incident as body slam for jaywalking is inaccurate and misleading, as it fails to reflect the reality of the situation and instead creates an exaggerated narrative. The escalation occurred solely because of Mr. Roberts' resistance to lawful commands." According to the police report, Roberts hesitated when Officer Nelson asked to see his hands. When Nelson asked him to put his hands above his head so he could be checked for weapons, they say he refused. After a brief struggle, he was placed under arrest. But Roberts feels he did nothing wrong and filed a complaint against Officer Nelson. Records show Chief Bammann conducted an internal investigation and at the end of July determined Officer Nelson acted in accordance with departmental policy.
I didn't know their policy was to allow officers to body slam 67-year-old disabled men.
Roberts says one split-second move by Officer Nelson turned his whole world upside down. Now he wants to see him held accountable.
I just couldn't believe somebody could do that to me.
Robert spent 6 days in the hospital and says till this day he still suffers some lingering effects from the incident. We reached out to Officer Nelson for comment, but haven't heard back. Last Thursday, Roberts hired an attorney who plans to file a civil rights lawsuit against the department. We'll, of course, stay on top of this story and keep you updated. Mike Mason, 19 News.
Okay, so here's the issue. And this is the problem with pretext, right? The first thing I need to do is define pretext. The best way to define it to people who aren't in the legal system, and you all know what this means, but pretext is basically ulterior motives, right? I want to get in this guy's pocket. Okay. In order to get in this guy's pocket, I know I have to observe this person commit some sort of a violation. Either I have to have reasonable articulable suspicion of crime, or I have to have probable cause of a traffic infraction. Now, in the absence of pretext, what other reason would there be for a Mansfield police officer on patrol at 12:45 a.m. to conduct an investigatory detention for an offense like jaywalking? It's obvious that there's pretext or ulterior motives. Now, the United States Supreme Court case of Wren tells us that pretext does not matter. But what is lost on these room temperature IQ police officers is that in the same way that it's not illegal to have ulterior motives, you also cannot create the scope of your investigation around those ulterior motives. The scope of your investigation has to be what you stop the person for until you're able to develop reasonable articulable suspicion of some other criminal activity and then pivot. It's no different than a traffic stop under Rodriguez, right? Rodriguez says you stopped him for a taillight out. Your job is to focus on the taillight out unless something happens along the way in your process where you develop good enough RAS that you could stop them on the street for something different. So if you're up to a car and you smell marijuana and marijuana is illegal, okay, now you have your RAS to pivot to a marijuana investigation. If you smell alcohol and they're operating a car, okay, now you have your RAS to pivot to a DUI investigation. But this is the situation that we're in. This person is stopped for jaywalking. That means that the scope of Officer Nelson's investigation is jaywalking. But Officer Nelson believes, improperly, that you can get in somebody's pockets simply because you're out with them. And that's not how it works, right? So just break it down to a completely elementary level. You stop somebody under Terry. It's a Terry stop. You do not get to conduct a Terry frisk, which is what Officer Nelson was trying to do here, unless you have some objectively reasonable information that Roberts is armed and dangerous. Okay? So the first screw up that Nelson makes here is that he gives Roberts a command to put his hands against this vending machine. The issue is he doesn't have the authority to give that command. It's not a lawful order. So Roberts says no, and then we get force, okay? And that's where they screwed up. There's only a couple different ways that you can get into somebody's pockets. Number one, you have to have consent, which we don't have here. Number two, you could have probable cause that there's some evidence of crime. Or three, you got search incidental to a lawful arrest. You've got probable cause of jaywalking, so you might have search incidental to a lawful arrest. But here's the issue. We have no information that he's armed and dangerous. We weren't even interacting with him long enough to figure out whether he was armed and dangerous. And the scope of our investigation is jaywalking. The problem that Nelson has is that jaywalking is governed by Ohio statute 4511.48. And if you'll look down here at the bottom of this statute, you'll note that it says that a violator of this section is guilty of a minor misdemeanor. Well, a minor misdemeanor under Ohio law is governed by 2935.26. If you look here, it says, when a law enforcement officer is otherwise authorized to arrest a person for the commission of a minor misdemeanor, the officer shall not arrest the person, but shall issue a citation unless one of the following applies, okay? The offender requires medical care or is unable to provide for the offender's own safety. Well, that will be true after Mr. Nelson gets a hold of him, but it wasn't true at the time that he got beat up by the police. Number two, the offender cannot or will not offer satisfactory evidence of the offender's identity. Well, he never was given an opportunity to give his identity. And if you listen to the body cam, it becomes clear that they actually know who this guy is and they've dealt with him before. And I guess they've harassed him a bunch, so they figured they'd just do it again. Didn't work out this time. Number three, the offender refuses to sign the citation. never was issued a citation. Number 4, the offender has previously been issued a citation and has failed to do one of the following. And then you have like basically a failure to appear or failure to comply, right? So if you don't have a lawful authority to make a custodial arrest, then that moves us over to another Supreme Court decision that will govern this officer's authority under the law. And that is Knowles versus Iowa from 1998. So the situation in Knowles was this. Officer stops a car for speeding, issues a citation, believes that because a citation is considered an arrest based on general jurisprudential understanding, that when you have a lawful arrest, then you have the right to search, right? Your right to search is only for, especially in, according to Arizona versus Gant in an automobile, is only limited to what you might find that are fruits of the crime. And so the Supreme Court said, well, the thing is, whenever you stop somebody for speeding, you're not going to be able to find fruits of the crime inside the vehicle. So there is no lawful purpose for you to be searching someone incident to a lawful arrest where you don't have a physical in custody arrest. The purpose of allowing police officers to search incident to lawful arrest is 1, for evidence of the crime, and 2, for officer safety, because they're going to put these people in their car. So they justify it under the doctrine of officer safety because, you know, they might have a gun, they might have a knife, whatever. Officers not expected to put people in their car when they might have weapons in their pocket for obvious reasons, right? What the court said was that you saw him speeding, your testimony and the fact that you got him on radar and all that stuff is all the evidence that would exist for the speeding violation. So you don't have a right to search looking for evidence of speeding because you already have it. And since this is not a situation where you could make a physical in custody arrest, there's no danger of officer safety problems because you're not going to put him in his car. He's not going to be coming with you. He can't compromise your safety because you're fixing to kick him loose with a citation. And so the court said in no uncertain terms that if you don't have a right to make a physical arrest and you don't have the opportunity to collect evidence of the crime, there is no CELA. And it's been very clear about this. So of the reasons that Nelson could get in his pocket, consent doesn't exist. Probable cause doesn't matter because Ohio law prohibits a physical in custody arrest for jaywalking. Okay. So the second that he said, put your hands against this vending machine, and Roberts said no, his options were to say, okay, give me your ID. I'm going to issue you a citation for jaywalking. His options were not to slam him on the ground and physically take him into custody. That's the first part of this. This is a slam dunk, easy to win Fourth Amendment violation. And because they slammed him, he spent like 6 days in the hospital and broke like 7 ribs. So we have serious damages here. You know, I talk about sometimes about how we don't have damages, right, from time to time. There are serious damages here. But it gets even better for the legal team for Mr. Robert, because the chief of police, Jason Bammann, conducted an internal review and said essentially that Nelson's conduct was within policy. And I know you guys will get a kick out of this. They investigated themselves and they found no wrongdoing, but that's going to be problematic for them under a Monell theory. And here's why. Remember that Monell theories are guided by what the municipality does in its dealing with these types of situations. And so under Monell, you have a claim if there's an official policy which says that you can do something that you're not legally allowed to do. That would be one theory under Monell. Or if there's a widespread customer practice, which very clearly that would be the situation here, because you had a sergeant here and, you know, oh, by the way, these guys were mocking him the whole time that he was on the ground, right? So it's obvious they were being smartasses about it. You've got a supervisor on scene. He's fine with what's happening here. It's pretty obvious that you could make the argument that's a widespread customer practice, but in addition to that, with the chief of police walking right into this trap of stupidity, he comes out and says, we didn't see anything going on here that wasn't within our policy. Well, 1, I would push back on that, and I'll explain to you why in a minute. But 2, that serves as a ratification theory, and that would be an official policymaker, the chief of police, coming out and saying, sounds like it's in policy to me. Okay, so we've got a slam dunk 1983 case, and just based on what Bammann said, a very good argument for a Monell claim for civil municipal liability. But in addition to that, I found a copy of their general orders, which hasn't been updated since 2019. And now we're going to walk through that to prove that the chief wasn't even familiar with what the policy says they're supposed to do. So let's take a look at it. So under General Order 1.2.4, search and seizure, there's a mandatory reliance on constitutional guidelines and obtaining warrants where practical. Well, You know, this wasn't a situation where you would obtain a warrant because there's no evidence that you're searching for that has anything to do with the original scope of jaywalking. But that's also why you don't have CELA, because you can't get evidence and there's no officer safety concern because you can't take him into custody physically. Just nobody told Nelson how law works, or the chief. But under stop and frisk, under their general order, which is 1.2.4, amazingly, the stop and frisk doctrine allows an officer to stop an individual when the officer can articulate reasonable suspicion that a crime has been or is about to occur. The stop and frisk doctrine also allows an officer to conduct a pat-down search of an individual only for weapons when the officer can articulate reasonable suspicion for fear for his safety or the safety of others. Well, okay, so there's a theory under Monell because that policy is incorrect. That is not what stop and frisk doctrine says. Stop and frisk doctrine says that stop is separate from frisk, one, and two, that frisk requires objectively reasonable information of being armed and dangerous. So there's your official policy under general orders that is illegal. Okay, so there's a Monell claim right there. Then under search incident of a lawful arrest, it says right here in their policy under 1.2.4, search incident to a lawful arrest, and for the protection of the officer and to prevent the destruction of evidence. The scope of the search is limited to the person and to the immediate area the detainee might have access to obtain a weapon or destroy evidence. Well, where's he going to go? How's he going to get a weapon? He didn't do anything except say no, and there's no evidence to be destroyed because you've got all the evidence of jaywalking you need. You got it on your camera, you got your testimony. You don't have CELA here, right? But the chief doesn't understand his own policy because it's very clear that the policy says you can't do what Nelson did. So you have conflicting policies. You got one policy that's illegal, and you got one policy that the chief's just not familiar with. But amazingly, under 1.2.5, under F, you have a minor misdemeanor here in their policy categorized. An officer may only make an arrest for an on-view minor misdemeanor when the offender refuses to sign the citation, requires medical care, or cannot or does not satisfactorily prove identity. Okay, guys, that mirrors the Ohio law. So they violated the United States Constitution, Fourth Amendment. They violated Ohio law, and they violated their own policy. And the chief came right out and said, we don't see anything wrong with it. So there you go. In closing, this is going to be a beautiful lawsuit because this is a situation where you actually have damages. And the beauty of this whole thing is going to shine through. And let me paint a picture for you. Imagine that a couple years from now, after qualified immunity is defeated, Roberts, now in his multi-million-dollar estate, no longer has to worry about being frugal and buying a 50-cent soda. He no longer even has to worry about walking across the street. He'll just buy the whole freaking vending machine. And you know what? Who's going to have to fill that vending machine? Officer Nelson. Officer Nelson is going to have to fill that vending machine because when he is exiled from law enforcement and decertified and can no longer work as a police officer because of his idiotic behavior here, he will have no choice but to do what everybody who leaves law enforcement does, which is to go become a car salesman, insurance salesman, or get a CDL. CDL is going to be the most practical because what's going to have to happen is he's going to have to drive the truck for one of these companies that refills the vending machine. So in my mind, what happens is Nelson leaves law enforcement. He goes to work for this company. And then every single week, he's the one who's going to be saddled with the responsibility of driving his beverage truck over to the Roberts estate and filling up all 30 of the vending machines that he has at every conceivable corner where there could potentially be enough room for a vending machine, and that vending machine would have to be wide enough so that they could put the handprints that Mr. Roberts will never have to put on a vending machine ever again, and then Nelson will have to come fill those up just for funsies. And that would be his punishment after he serves his lengthy prison sentence and has to pay out of pocket to the extent that he has to file personal bankruptcy. Now, isn't that the way this story should end? Anyway, I thought you guys would get a kick out of that. Slam dunk case. Lawyers are going to tear them apart. They have no defense whatsoever. I believe this will be a multi-million-dollar settlement. I'll keep you updated when I find out what happens ultimately. But hey, if you're interested in the job of being the chief of police of Mansfield, Ohio, Bammann doesn't know his ass from a hole in the ground because he doesn't even read the policy that he applies to other people. The policy is illegal, and he routinely encourages his officers to break the law and comes out and tells the public that they didn't do anything wrong over jaywalking, guys. Over jaywalking. So, Anyway, just wanted to put it on your radar. Got a bunch of people asking me to cover it. That's my take on it. Let me know what you think about it in the comments. I'll probably notice some issue that'll come up in the comments that'll ultimately end up on the following week's episode of The Rebuttal or in a companion blog over on Substack or both. I'd like to invite you over to Substack. It's absolutely free to join. You can join on a paid tier if you want to, but that's only for people who want to support the channel monetarily. I don't put anything on Substack that people have to pay for. I'd also like to invite you to check out the upcoming early week videos, which are going to be called The Rebuttal, and we're just going to be talking about whatever came up in the comments from the videos the week before. If you don't want to go to Substack, but you would like to support monetarily, I'll leave my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.